Good afternoon. I call to order today's en banc hearing on supplier consolidated billing at docket number M-2018-264-5254. I am Administrative Law Judge Dennis Buckley. I note that this is the second session in this matter, the first having taken place on June 14th, 2018. This hearing is being video streamed live on the Commission's website and is also being transcribed by a court reporter. I hope that all witnesses have signed the hearing report form, or green sheet as we call it. If you haven't, then just see us at the break and you can sign it then. I also would hope that any written testimony or written comments that the parties care to submit have been brought forward. Again, if I don't have those, please bring those to me now. I would ask that everybody in the hearing room turn off their cell phones or mute them if you have not already done so. These are non-adversarial proceedings for receiving testimony from witnesses. Following up again on the initial session, I would note that interested persons are welcome to submit written reply comments by Friday, August 24th, 2018, referencing the docket number M-2018-264-5254. Those reply comments can be mailed to the Commission at the following address, sent to the attention of Secretary Rosemary Chiavetta, Pennsylvania Public Utility Commission, Commonwealth Keystone Building, 2nd floor, 400 North Street, Harrisburg, Pennsylvania, 17120. Reply comments may also be filed electronically through the Commission's e-file system. At this time, I would ask Chairman Brown, Vice Chairman Place, and Commissioners Coleman and Sweet if they have any opening remarks that they would care to make. Chairman?
Thank you very much, Judge Buckley. Let me just first say, want to thank everyone for participating in this very interesting, very educational conversation that we are having on supplier consolidated billing. This is our second en banc proceeding, so I appreciate all of you that are here, especially our EDCs, and I know we have some reply comments from our EGSs. I want to take a moment to read the comments from Commissioner Coleman, who could not be here, and is very sorry that he could not be here, and he wanted to make sure that I put his comments on the record. And I will be reading it in his voice, or first person. Let me begin by commending the Commission staff, particularly Dan Mumford, Director of our Office of Competitive Market Oversight, for organizing our agenda for today, and Chief Judge Charles Rainey, but we know we have Judge Buckley here, for presiding over this en banc hearing. I would like to thank all of the parties for participating today and for all of those who have submitted comments at this docket. Regrettably, my schedule does not allow for me to participate in the en banc hearing today. However, my team and I look forward to reviewing all testimony submitted as well as a copy of the transcript of this hearing. So those are comments from Commissioner John Coleman. And at this point, I will open it up to the other commissioners, and you will see that we call them in a specific order. So I will call on Commissioner Sweet, who is next.
Oh, thank you, Madam Chair. I do not have any comments to offer at this time.
Commissioner Kennard.
Thank you, Madam Chairman. Thank you, Judge Buckley. Thank you, Dan Mumford, and thank you, Chris Brown. And thank you, everyone, for attending here today. We've reviewed your comments. They're very informative. Look forward to the testimony on this important issue. Our purpose here today is to hear what you have to say. So the less we say, the quicker we can get to the objective of today's hearing. Thank you.
And finally, Vice Chairman Place.
Thank you. And I also will be brief, not much to add other than thank you as well. Of course, balancing these challenges of the leveling a playing field, consumer protections, Chapter 14 directives, and the technical challenges that would ensue if we went down this route, and why dual billing, for example, isn't a suitable solution. Particularly things of my interest, but of course that covers the panoply, so I look forward to the conversation.
Thank you, Chairman and Commissioners. We will be hearing from two panels this afternoon as shown on the agenda, electric distribution companies and electric generation suppliers. At the conclusion of each panel, there will be an opportunity for remarks and questions from the commissioners. We will have a break between panels. At this time, I would like to admit into the record a number of documents that have been provided. We'll start with the Energy Association of Pennsylvania, their statement number 1, as well as the Supplier Consolidated Billing Coalition Exhibits 2 and 3. And I also note 2 exhibits from Duquesne, Duquesne Exhibit number 1, Duquesne Exhibit number 2. I understand that the Duquesne witness is going to be testifying from these documents. While technically hearsay, they're admitted into the record for whatever weight the commission would care to afford them. Let me correct myself. The previous, John, what I previously stated were exhibits of the Pennsylvania Energy Association and the coalition. Let's just mark those as statements. All right, a couple of quick rules of the road here, if I may. Each witness should speak slowly and clearly into the microphone. Please make sure your microphone is actually on before you start speaking. You'll know that by the little green light that will appear. Please identify yourself by name and title for the commission and the court reporter, as well as the party for whom you are offering testimony today. We will proceed according to the agenda. However, I note one change in that the representative of Shipley Energy, Ms. Greenholt, will go out of order before the EGS coalition. The amount of time afforded for testimony by each group of witnesses appears on the agenda. Please note that Mr. Mumford, sitting next to me, has a yellow card. That will mean you have 1 minute to sum up your testimony. And if necessary, he has a red card, which means you have 30 seconds left to conclude your testimony. With that, Mr. Fitzpatrick, would you care to proceed, sir?
Thank you, Judge Buckley. Thank you, Chairman Brown and commissioners. It's a pleasure to be here, and thanks for the opportunity to testify regarding the supplier consolidated billing. I did provide a written summary of the main points that I want to make today. Before I launch into them, just very briefly, I want to state that my perspective on this is shaped by long experience with the Competition Act that started when I was a Senate staffer, along with you, Chairman Brown, working on this competition law. I was one of the people in the room that helped to draft it. Don't claim that I'm the draftsman. I was just one of many. I had a lot of friends that had their hands in that. So I saw it then. I saw the Competition Act and saw how it played out and was implemented as a lawyer who represented MedEd and Penelec in both their restructuring cases as well as the restructuring cases of the other utilities back around the 1998 timeframe. I was a commissioner then, honored to be a member of this commission from 1999 to 2007. And of course now as a president of the Energy Association, the trade group for electric and gas utilities. Now that experience, I don't think that makes my opinion about the question we have here today better than anybody else's, but I do think from that experience I have an understanding of the Act and its history. Having said that, let me get right to it here. Our first point is that we believe supplier consolidated billing is inconsistent with chapters 28 and 14 of the Public Utility Code. If you pull back from the Competition Act and just look at its outline, you can see that the Act contains separate sections setting out the obligations and requirements for both electric distribution companies and electric generation suppliers. Section 2807 is entitled Duties of Electric Distribution Companies, and subsection C of that section is entitled Customer Billing. This subsection provides that subject to the right of a customer to choose to receive a separate bill from its EGS, the EDC may be responsible for billing for all electric services regardless of who provides them. And I note that there is no similar language in section 2809, which deals with EGSs, which authorizes EGSs to provide consolidated bills. The general language in the Competition Act providing that the Commission, quote, may require the unbundling of other services, close quote, cannot reasonably be construed to empower the Commission to undo the very specific directives in the very same act establishing that customer billing is a duty of the EDCs. And duty, again, is the term that's used in the heading of Section 2807. And I think this is dictated by the Statutory Construction Act, which says that the particular controls the general. Furthermore, Commonwealth Court has held that EDC obligations under the Act may not be delegated to EGSs, and that's the Dauphin County Industrial Development Authority case that I cite in my statement. This conclusion, I think, is reinforced if you just look at other provisions, many other provisions in both Chapters 28 and Chapter 14, that make EDCs responsible for customer service functions that accompany billing. And for example, Section 2807D provides the electric distribution company shall continue to provide customer service functions consistent with the regulations of the Commission, including meter reading, complaint resolution, and collections. Chapter 14 contains really a myriad of provisions imposing duties regarding customer service on public utilities, a term that includes EDCs but does not include EGSs. Second point, as a matter of policy, putting the legal argument aside, as a matter of policy, supplier consolidated billing should not be required because the costs of implementing it for both the EDCs and for the Commission are not justified by the speculative benefits to consumers. Implementing supplier consolidated billing would entail significant costs for EDCs and for the Commission. Two EDCs have estimated costs of $4.6 and $4 million, respectively, to change their systems to provide this service. Supplier consolidated billing would also result in a wasteful duplication of costs, as EDCs would have to maintain their customer service systems and processes for customers on default service and for customers purchasing from EGSs, because they could choose to return to default service, and EDCs have a duty, of course, to serve them. The Commission would also incur significant costs in time and resources to implement and oversee supplier consolidated billing. The EGS Coalition for Supplier Consolidated Billing itself proposes a 14-step process even before the issuance of an implementation order and review of the EDC compliance plans. After implementation, the Commission would be required to oversee an uncertain but potentially large number of EGSs providing these important customer service functions, as opposed to regulating a handful of EDCs today. The benefits of supplier consolidated billing to customers are speculative. As with previous market enhancements, some EGSs cite the potential for innovative new products, but there's no certainty of that, and it is unclear whether, on balance, customers would be better off once you consider the costs. And that assumes, I guess, that the customers bear the costs, which I think, of course, is another question here. If this is done, who should bear the costs of doing it? In light of the history of market enhancements, the Commission should not require supplier consolidated billing or any new enhancements without evaluating lessons learned from previous enhancements. The cost of these enhancements to customers and EDC shareholders, but not to EGSs to this point, have run at least in the tens, if not the hundreds of millions of dollars, and the benefits to the market are unclear. This evaluation of lessons learned, I think, is particularly appropriate in light of a growing body of information from other states, most recently Illinois, indicating that the customers served by competitive suppliers pay much more on average than the customers that choose utility default service. So I think to sum it up, in light of the likelihood that a Commission decision to require supplier consolidated billing would be reversed in court for the reasons I explained, and also the substantial cost and time and resources that would be required to implement it, EGSs should pursue authorization to provide this service from the Pennsylvania General Assembly rather than the Commission. Thank you very much for your time.
Chairman Brown, Commissioners Kennard, Sweet, and Coleman. My name is Lauren Feldhake, and I am the Vice President of Customer Operations at PECO Energy Company. I would like to thank you for the opportunity to appear today to support the Commission's inquiry on supplier consolidated billing. I would note that I have had direct responsibility for credit and collections, billing, and the call centers, as well as low-income programs, and I now have overall responsibility for customer operations. Consequently, I am acutely aware of the challenges and complexities of providing service to customers consistent with the laws, regulations, and processes in place in Pennsylvania. As you know, PECO has made significant investment in recent years on retail market enhancements. Indeed, PECO estimates that over $31 million has been spent on retail market enhancements implemented since 2010 in its service territory alone. It is also important to be clear that EGSs can offer innovative pricing right now. With bill-ready billing and AMI meter data, EGSs can already offer time-of-use rates, free Saturdays, or even flat bill for basic generation charges. EGSs also currently have access to a variety of customer data through the eligible customer list, which includes customer usage data, unless a customer restricts it. For non-basic generation value-added product services, EGSs are free to independently offer and bill such products and services to customers. It is also important to note that even if SCB is offered by some EGSs, PECO and other EDCs will still have to maintain their full customer support infrastructure, call center staffing, billing systems, complaint resolution, etc., to serve default service customers and customers taking service from other EGSs. EDCs would also need sufficient infrastructure to serve customers in case an EGS using SCB exits the market or elects to discontinue SCB, or if shopping customers return to default service. It is also likely that PECO would have to hire additional personnel to coordinate billing complaints with EGSs offering SCB and develop and implement new call center scripts and customer service scripts. In other words, SCB would add another layer of complexity that the Commission must carefully consider. PECO previously submitted detailed written comments addressing SCB topics identified by the Commission and supports the testimony being provided by the Energy Association of Pennsylvania today. In my testimony, I will focus on 4 topics: PECO's 500,000 dual service customers, customer protections, purchase of EDC receivables by SCB's suppliers, and implementation costs. PECO has over 500,000 customers that receive both gas and electric service from the company, which raises unique implementation and cost issues associated with SCB. PECO's dual service customers who currently receive a single bill for all gas and electric charges would receive 2 bills if their EGS were to participate in SCB, and PECO would need to create additional bill processing options for those customers. As a general matter, PECO believes that SCB would create a greater risk for those customers. Confusion as well, because both the EGS and PECO call centers would be required to address billing issues, EGS for electric and PECO for gas. This confusion could create delays in the resolution of customer billing issues and lead to lower customer satisfaction overall. SCB would also create particular challenges for dual service customers because of the uncertainty on how payments should be applied. For example, past due gas and electric charges have a higher payment priority than current and electric charges. If PECO's billing responsibility for current electric charges were transferred to the EGS, it is unclear how whether future payments made to PECO would apply to past due electric charges. PECO also directly receives LIHEAP grants on behalf of dual service customers and presently applies those grants first to past due payments and next to current bills, and then retains any of the remainder as credits on those customers' accounts. Similar to payment priority, the receipt and application of LIHEAP grants would have to be modified to clarify if or how LIHEAP grants received by PECO could be applied to charges for electric service. As previously discussed, PECO and other EDCs invest a significant amount of time and resources in implementing detailed customer protections under the Public Utility Code and the Commission's regulations. With regard to termination of service, those requirements include permissible grounds for termination, customer notices prior to termination, and emergency circumstances that would postpone a termination. If EGSs offering SCB would be involved in the termination process, PECO is concerned about a potential for increased risk of harm to customers. That increased risk, at least in part, stems from the tension, suppliers' interest in payment, and the customer protections mandated under the law. This could increase time and expense associated with receiving customer payments. PECO firmly believes appropriate procedures must be developed and in place before SCB is implemented to ensure that customer protections are preserved and maintained under SCB. That will be no small task. Looking at the EDC side of a possible SCB implementation, PECO would need to modify existing processes to enable the company to, 1, know if a payment has been made to an EGS so that termination should be stopped, 2, access customer billing information to make required phone calls, 3, ensure the termination is for failure to pay basic service charges as opposed to any value-added services, 4, ensure the termination is consistent with the winter termination restrictions for low-income customers, and 5, communicate the termination location so the EGS would charge the appropriate restoration fee. PECO also believes if an EGS is permitted to order an EDC to terminate services, the EDC's responsibility should be limited to the physical termination of service. The EGS directing the termination should be fully responsible for the termination, and the EDC should be held harmless from any claims that service was terminated unlawfully. Even with appropriate procedures in place for both EDCs and EGSs, offering SCB that address these termination of service issues, PECO believes that the Commission should consider how involving an additional entity in the termination process may create confusion, and customer service delays. For example, a customer facing possible termination may be unsure about which entity to contact to confirm low-income status, to avoid a winter termination, or simply to have questions answered about his electric charges. Now turning to low-income customers. Service of these customers requires adherence to additional customer protections under the Public Utility Code and the Commission's regulations. These protections include restrictions on winter terminations, the assessment of security deposits, and LIHEAP recipient late payment fees. EDCs ensure that these protections are maintained, also assess customer eligibility for and administer a variety of low-income programs like CAP that can benefit low-income customers by reducing their bills. Under SCB, EGS capabilities and obligations concerning low-income customers and low-income programs must clearly be identified by the Commission in order to ensure that the level of service provided to low-income customers is not degraded. Next, PECO believes that a purchase of receivable program in which EGSs purchase EDC receivables raises a variety of practical issues that the Commission would need to address prior to SCB implementation. For example, EDCs would need a high degree of confidence that 1, the EGS would actually pay money owed, 2, in the unlikely event of an EGS default, EDC customers would be given a credit for the amount paid to the EGS for their EDC charges. Establishing appropriate bonding requirements for EGSs seeking to offer SCB and manage payment EDC charges would help mitigate the risk of non-payment to an EDC. Such bonding requirements would need to be significant and could be prohibitive for many EGSs. For example, if all of PECO's shopping customers receive supply from EGSs implementing SCB, the company estimates that exposure for distribution charges each billing cycle would be approximately $51 million. In addition to meeting bonding requirements, EGSs offering SCB would also need the capability to bill for all distribution charges collected by EDCs, including those that are separate line items on the EDC bill. Those items include distribution system improvement charges, state tax adjustment surcharges, and energy efficiency and conservation program costs. Finally, PECO requests that the Commission definitively assign responsibility for SCB costs before moving forward with SCB. PECO believes that all EGSs should bear the cost responsibility. This would include responsibility for costs incurred by EDCs even in the event that no or very few suppliers elect to implement SCB. With regard to PECO's costs in particular, the company preliminary estimate for IT and business costs is $4.6 million, and these costs are in addition to the $31.5 million already spent on other retail market initiatives. I'd like to thank the Commission for the opportunity to provide testimony in this proceeding. PECO looks forward to working with the Commission and stakeholders to continue to support Pennsylvania's retail electric market. Thank you.
Good afternoon. My name is Chuck Fulham, and I'm Director of Rates and Regulatory Affairs, Pennsylvania for FirstEnergy. In this role, I primarily support FirstEnergy's regulated Pennsylvania operating companies on rate-related matters, including retail market matters. With me today is Greg Hussing, our Director of Customer Service, and he's available in order to answer any technical questions the Commission might have. I'd like to start my testimony today by quoting the direct testimony of Christopher Callagher provided on behalf of Direct Energy and RESA in MedEd's first default service plan. Specifically, at page 34 of his direct testimony, Mr. Callagher is asked whether he can describe the prerequisites that are needed for a successful retail energy market for residential and small commercial customers. In response, Mr. Callagher offered the following. The first and the most important prerequisite from my perspective is the purchase by utilities of supplier accounts receivables, POR, without recourse. This program, when coupled with utility consolidated billing, is a key component in developing a successful retail energy market. In response to this position repeatedly taken by the retail community, FirstEnergy's PA EDCs have since created and implemented a purchase of receivables program without recourse. Given that the Commission, along with all EDCs and PA, has largely implemented all the prerequisites that RESA and its memberships have historically claimed were needed for a successful retail energy market, it is troubling that the same parties now assert the need for supplier consolidated billing in order for the retail market to succeed. The benefits cited by EGSs in comments and testimony to this point that are to be gained from supplier consolidated billing generally fall into three categories. One, it will enable EGSs to market a multitude of new and exciting competitive products and services. Two, it would enable EGSs to develop and customize more versatile and customer-friendly billing systems. And three, it would enable direct relationships between EGSs and their customers. In my opinion, none of these arguments are valid as explanations to support the need to implement supplier consolidated billing in Pennsylvania. First, EGSs have argued that they face significant obstacles in their ability to offer customers new and exciting products and programs such as rooftop solar, smart LED lighting, smart thermostats, energy efficient appliances, and home battery storage because they cannot bill for such products on a utility consolidated bill. While EGSs may face obstacles in their ability to bring these products to the market, it is not because they cannot bill for such products on a utility consolidated bill. It is worth reminding everyone gathered here that EGSs wanting to offer non-basic electric service or bill for commodity service already have the ability under a dual billing arrangement. More to the point, companies other than EGSs do not bill for rooftop solar or home battery storage on utility consolidated bills. Despite that, our companies have seen a 40% growth in residential rooftop solar installations across our footprints in 2017 as compared to 2016. Similarly, in our New Jersey EDC, we've experienced an annual growth rate of 31% for the same segment between 2014 and 2017. Interestingly, not one residential rooftop solar unit interconnected with FirstEnergy's Pennsylvania and New Jersey EDCs have been built on a utility consolidated bill, yet the growth rate for such installations remains high. Furthermore, numerous retailers such as Home Depot, Lowe's, Best Buy, and Amazon offer energy efficient appliances to customers in the company's service territories with apparent success. In fact, since our companies implemented our energy efficiency and conservation programs, which began in 2010, we have verified that over 223,000 energy efficient appliances have been acquired by our customers. During that same period, nearly 28 million energy efficient lights and thousands of programmable thermostats have been documented as acquired by our customers. None of these items appeared on our utility consolidated bills. Given these statistics, I simply cannot accept that these products and services cannot come to market unless they're paid for on a consolidated bill. The second argument advanced in support of supplier consolidated billing is that it would enable EGSs to develop and customize more versatile and customer-friendly bills. Those EGSs have assured that they also intend to follow all Commission regulations and that these bills will, among other things, enable EGSs to bundle products and services with the electric commodity. However, those advocating for supplier consolidated billing seem to ignore the fact that the Commission has issued specific regulations that dictate the information a bill must include, such as separately identifying EDC and EGS charges, that present basic service charges distinctly separate from and before charges for non-basic service, and to present generation charges in a standard pricing unit for electricity that has been Commission approved. While I'm not a licensed attorney, I believe that these regulatory requirements clearly prohibit the bundling of products and services that either EDC charges or even the electric commodity under the Commission's existing regulations could be bundled together, even if the EGSs are performing the billing function. In sum, the Commission's billing requirements are designed to be informative, transparent, and are not intended to allow the bundling of products and service or the bundling of EGS and EDC charges. To do so would obscure the price of electric commodity and reduce transparency. Therefore, those arguing for supplier consolidated billing with the idea that it will allow EGSs to bundle products and services with the electric commodity cannot possibly do so while at the same time adhering to existing Commission regulations regarding bill format for residential and small commercial customers. Finally, I'd like to address the arguments set forth by advocates of supplier consolidated billing who argue that it would address the absence of a direct relationship between an EGS and its customers. During the en banc hearing on June 14th, testimony was offered by proponents of supplier consolidated billing regarding the fact that customers of Amazon aren't billed by Federal Express, presumably equating EDCs to Federal Express, a delivery mechanism. And while it is true that Federal Express doesn't send a bill to those customers, it is also true that those customers don't receive a bill from Amazon. It is my understanding that Amazon's primary billing platform is a web-based design and accepts most major credit cards and some gift cards for its products and services. Purchases from Amazon show up as a line item on a credit card statement, much the same way EGS commodity service shows up on a utility consolidated bill today. In 2018, it just doesn't seem logical to assume that issuing a bill to a customer is the best way to build a direct relationship with that customer. In fact, a growing number of our customers are electing not to receive a paper bill. Currently, over 1.5 million of our accounts, or 25% of our customers, are enrolled in FirstEnergy's electronic billing, meaning we do not issue a paper bill, but instead either deliver PDF image to the customer's banking site or to our internal customer portal for customer access. That number is growing every month. So having addressed the arguments raised by proponents in support of supplier consolidated billing, I'd like to close with some reasons against adoption of that model. First, customers generally trust their local utility. Our EDCs routinely rank high in areas such as trustworthiness with customers. I would expect that the Commission would prefer the billing agent for regulated service to be an entity perceived as trustworthy by customers, not to mention an entity over which the Commission exercised comprehensive jurisdiction. Second, the implementation of accelerated switching, seamless moves, and instant connects took a total of 2.5 years. Those efforts pale in comparison to full implementation of supplier consolidated billing, which would require significant IT and business process changes. Finally, 3 billing options exist in Illinois' retail electric market. Those include consolidated utility consolidated billing, dual billing, and supplier consolidated billing. I've reviewed the Illinois Commerce Commission's Office of Retail Market Development 2018 annual report, which states at page 13, while all suppliers are currently using utility consolidated billing and purchase of receivables for residential customers, it is worth noting the widespread use of utility consolidated billing for non-residential customers as well. In May 2018, alternative retail electric suppliers used utility consolidated billing for all non-residential customers for which it was available. Given all of the alleged benefits of supplier consolidated billing, it certainly begs the question why, in a jurisdiction that actively allows all 3 billing options, all suppliers are currently using utility consolidated billing for their residential customers. In conclusion, the Commission has continually recognized the paramount importance of price transparency in assisting customers to make informed purchasing decisions relative to their electric generation. It is critical that the Commission maintain clear jurisdiction over the billing function in order to ensure that this focus on pricing transparency continues into the future. In my experience and opinion, that can only be preserved by maintaining the current billing structure in Pennsylvania. I thank the Commission for the opportunity to testify today on such an important topic, and I look forward to your questions and further dialogue on the subject.
With 10 minutes, I don't have time for an intro, so I'm going to just go into it. The coalition states the supplier consolidated billing would be a game changer, taking Pennsylvania's retail market into the next level. What suppliers argue is that shopping numbers are stagnant or peaked before 2014, therefore the market needs something to get to the next level, which means they want more customers and more product offerings to illustrate retail market success. Conveniently, two things that benefit suppliers. What I consider success is that 95% of homeowners and 93% of renters are aware of their ability to shop for electric supply. What I consider success is enhanced EDC and EGS information sharing, lower barriers of entry for all suppliers, competitively procured default service, and a choice of 2 billing options that are properly regulated, consistent with Chapter 28. I've never been one to negate that default service is a choice. In fact, it's my understanding that some of you choose to receive default service. That's your right. On a statewide basis, default service has met or beat supplier pricing between 2000 and 2014. Collectively, these attributes evidence that a properly functioning and workable competitive retail electricity market exists in the Commonwealth, which was the goal of RMI. There's nothing wrong with the current level of competition in Pennsylvania. We are and continue to be a national retail markets leader. Pennsylvania deregulated 3 years before Texas, and we chose a different model. Rather than mandate supplier consolidated billing and an oppressive provider of last resort price that forces people to shop, Pennsylvania chose to allow 2 billing options, either a consolidated bill from an EDC or dual bills, one from your EGS, one from the EDC, and as regulated default service with competitive procurement designed to ensure the least cost to customers over time. This works for Pennsylvania consumers. EGSs have the ability to directly bill residential customers. It's through a dual bill, and it's the EGSs that choose not to do so. What I have found as a participant in the retail market, when looking at statistics of dual bill use for residential customers since 2010, and when reviewing supplier websites that offer service to residential customers, is that the option of receiving a dual bill isn't typically discussed. As I'll explain in a moment, I'm about to be with my 4th EGS in approximately 3 years. Never once have I been informed of the ability to choose a dual bill. Second, in looking at the use of dual bills for residential customers, if you look at what I gave you, I'd characterize it as statistically insignificant since 2012. A review of the retail choice activity reports from 2012 and 2016 illustrates that fact. EGSs aren't even using the tools available under the law before repeatedly asking the Commission for something else. In addition, when reviewing suppliers' websites and offers for residential customers, not only did I not find any information about the option of receiving a dual bill, but instead I found language that I would characterize as a selling point for EDC consolidated billing. Listen to this introductory language. In addition to offering plans that fit your unique energy needs, you won't have to do anything differently. Your local Pennsylvania utility company will continue to deliver your energy, read your meter, and send your bill. You know, that's right. That's what Chapter 28 requires. When explaining parties' roles with the energy choice, the utility, they deliver the energy to your home, send your electric bill, and respond to consumers' emergencies. Again, this is a correct statement of the law. Finally, where there are offers, I noticed a tagline. You will continue to receive the same bill from your utility. They deliver the energy, we provide it. That explanation seems simple to me. It's not confusing at all. If the EGSs would use dual bills, they would get the direct relationship they seek, and as discussed last time, they'd get customers that open their bills. They could also get the information they seek, how soon a customer pays, what payment method customer used, whether the customer pays in a lump sum or through installments, and they could also include messages, have more freedom over bill design, and opportunities for upselling. But here we're saying include additional products and services that are designed to meet a customer's unique energy needs. What we're also to understand is that through the ability to send consolidated bills, EGSs will finally be able to forge direct and long-term customer relationships. Based on my experience and observations to date, I don't believe this is necessarily true. I do support the competitive retail market, therefore I am a participant. I was on default service, I shopped once, and I chose another EGS. Since choosing my second EGS less than 3 years ago, my account has gotten assigned twice. First to EGS number 3, and now to EGS number 4. That assignment will actually take effect next week. Assignment isn't the only way EGSs has severed long-term relationships with customers. We've had EGSs go out of business, EGSs drop customers back to default service, and EGSs willfully break contracts with customers. The coalition claims that they can't make long-term relationships with customers because they can't give a consolidated bill. It's been my experience that I can't make a long-term relationship with my EGS because they care more about their profit margin than keeping customers. I don't believe for a second that had either EGS numbers 2 or 3 had been able to provide a consolidated bill, that they wouldn't have sold their book of business to instead keep a long-term relationship. Do you know the only consistency that I've had? I get my bill from my EDC. It's because it's what's statutorily mandated. I was never given an option to get a dual bill, and my EDC isn't transient and is fully regulated. I'm okay with that. The legislature, I would argue, is okay with that. That's why Chapter 8 is written the way it is, so customers would still deal directly with EDCs. If this weren't the law, I'd have the potential of being billed by the 5th different entity in less than 4 years. Talk about confusing. Rather than discuss who's providing the bill, when you listen to the discussion and the types of innovative products that EGSs are seeking to offer, we should have a real discussion of how these products, if used on a mass market basis, impact statutorily mandated programs. As much as EGSs would like it, this decision cannot be made in a vacuum. Aside from the purported flexible pricing plans and insurance offerings such as surge protection, some of the products that are being discussed here have an EE or demand response component. What we should be discussing is whether Act 129 mandates for EE and DR are even necessary anymore. If the PUC and the EGSs support repeal of those mandates, it lets these products up to the competitive market, which they apparently want, are happening anyway, since value-added products have been available for at least the last 2 years and would have tangible benefits for customers by returning more than $200 million a year. Customers have already paid more than $1 billion for these programs. As a result, repealing these mandates would have an immediate effect on customers' energy burden, as they would no longer be charged for something that isn't needed. Promises to follow any commission orders, especially with regards to Chapter 56 and 14 specifically, without more, are hollow. As already mentioned, Pennsylvania has a history of suppliers not being in compliance with many of the laws. In fact, since 2010, the PUC has revoked at least 1 license due to misconduct, has ordered more than $3 million in civil penalties and more than $22 million in refunds. When lumping in other amounts, including hardship fees and funds, the total is more than $25 million. The one thing all those suppliers had in common, they promised to follow the law too. And I know that because you would have never given an EGS license otherwise. In addition, and as pointed out, a number of the products described in comments here would require Chapter 56 waivers or a rewrite. It's convenient that the coalition glosses over this by stating simply, to the extent that new rules need to be established, this is an issue that could be discussed among stakeholders with a recommendation being provided to the Commission. When I worked for the Commission and we ordered dramatic changes that affected the retail electric market, they were based on evidence of customer benefits, not just hyperbolic promises. For example, when we did the final omitted rulemaking for accelerated switching, we had real, objective evidence that the average switch time was taking between 16 and 40 days. And because of that, customers were being substantially harmed because they were stuck in egregious contracts they no longer wanted. So we took quick action, we had swift deadlines, and made a change to demonstrably benefit customers. Here, in contrast, we continue to have a discussion about a mechanism that has been denied at least twice by this Commission, as recently as January by a vote of 5-0, and is nothing more than an articulated want by the suppliers to increase their revenues under the guise of innovation, with no demonstrated need or actual evidence of customer benefits. I read a blog post on this subject recently that suggests the crux of the anti-argument appears to be that those who advocate for customers want all customers to have fewer choices. I take issue with that statement because it couldn't be further from the truth. What we are advocating for is demonstrated evidence for the legal authority and actual evidence of the need and benefits of supplier consolidated billing for anyone other than suppliers before this Commission or the legislature attempts to so fundamentally change what was decided in 1996. At minimum, there should be a push for more widespread use of dual billing so we can really understand the shortcomings of this option in Pennsylvania. Because it hasn't been used for the residential class, this evidence doesn't currently exist. In the interim, while I greatly support the competitive retail market, I, like you, am obligated to follow the law. So that means customers in Pennsylvania have two options: either utility consolidated billing or receiving a dual bill, pardon me. The suppliers would love a proclamation that they can do this, and we can figure out all the details later. That isn't how we regulate in Pennsylvania, because our customers are going to live with this, and they deserve better. Thank you.